The Judiciary and Civil and Criminal Jurisprudence Committee will now come to order. We will start in a subcommittee with my good friend, Senator Mosley, Senate Bill 262. Proceed when you are ready. And for all the witnesses, since we have a lot of bills today to hear in exec, if we can keep our time limits to roughly 2 minutes, we'd greatly appreciate it.
Good morning.
Ready. Good morning.
I am Senator Mosley, representing the 13th Senatorial District. Thank you for hearing this bill today. This bill, SB262, under this act, the obligation of a parent ordered to pay child support shall abate in whole or in part if the other parent has permanently transferred custody of the child to a third party without first obtaining court approval. Additionally, in custody cases where court finds each parent to be unfit, unsuitable, or unable to be a custodian, and the court determines that custody, temporary custody, or visitation with a third party is in the best interest of the child, the court shall notify the child's relatives within the third degree and any persons with whom the child has resided within 5 years, that such persons may intervene to seek third-party custody, temporary custody, or visitation. If such persons are not already a party to the action, any person may petition the court to intervene as a party of interest at any time, and the court shall allow such intervention as a matter of right. Priority and preference for third-party custody shall be given as set forth in the Act. No order denying third-party contact with the child shall be entered by the court against third party who has not been made a party to the action unless the court finds that the third party may be not found and joined as a party. This act modifies the definition of relocation of a child in the custody arrangement to include the permanent transfer of custody of a child under a court order. In cases involving a proposed permanent transfer of custody to a third party, the legal custodian shall give notice of the proposed change in residence or location of the child to any non-custodial parent whose last known address is on record with the court as provided for in the Act. Such notice shall be in writing and shall be provided at least 60 days in advance of the proposed transfer. The notice shall not include the actual address to which the child shall be relocated, but shall include information on the non-custodial parent's rights to intervene and seek custody of the child after August 28, 2025. Every court order establishing or modifying custody shall include the addresses of the legal custodians and non-custodial parents as specified in the Act. Current law requires each party in child custody proceeding to give information as to the child's residence over the prior 5 years under the Act. Any person who knowingly, purposely, or intentionally fails to give accurate, full, and complete information shall be guilty of a Class A misdemeanor and shall be reported to the local prosecuting or circuit attorney. Under current law, any person may file a petition for appointment as guardian of a minor. This act requires that the minor not be currently subject to a prior custody order. Petition shall include information about the minor's residence over the prior 5 years. Notice of the guardianship petition shall be given to the person identified as having physical custody of the minor over the prior 5 years, and each of these persons shall have the right to intervene and seek guardianship of the minor. Failure to give notice to shall be grounds to set aside the guardianship appointment. Priority and preference in the where of guardianship to a third party shall be given and specified in the Act. That is the summary. This bill came about from a family that reached out to me who there was a young man who was 6 years old. He was an interracial child. His mother ended up going to jail, and he was with his grandmother, her mother, after she went to jail. She also ended up, not shortly after, passing away. The child was given to the grandparent, the mother's grandmother, and she gave the child to another relative. She didn't want him. So the father reached out trying to get custody. They refused to allow him to get custody. Another relative of the father's side tried to intervene. They wouldn't allow her to intervene. They even stopped the young man from being able to see any person on the father's side, wouldn't be allowed to talk to them or anything. So from 6 to 18, he had no contact with the father's side of the family. So this is bill is trying to rectify that from not happening again. He suffered a lot of mental issues. He's because of this. Only reason the relative wanted him was because he received Social Security. She wanted those checks. So he suffered from, since he was an interracial child, they would call him the N-word a lot of times and refer to his mother as a wigger. So that caused him a lot of mental issues. Like I said, now that he's 18 and above, he's able to be with his other side of the family. But this is to stop that from occurring again, well, in hopes.
We're going to take a brief pause and exit the subcommittee and try to establish a quorum here. Mr. Secretary, call a roll.
Senators Schroer.
Here.
Gregory 15. Brown 26. Coleman. May. Roberts. Schnelting.
All right, having a quorum, we're going to go back into the public hearing on Senate Bill 262. Do we have any questions for Senator Mosley? Seeing none. You did such a great job. We have no questions for you. The first witness in support, please come forward. You'll have 2 minutes. First witness in support. Seeing none. Any witnesses in opposition to Senate Bill 262? Seeing none. Any for informational purposes? Senator, you did such a great job. Nobody's even coming forward to add to what you have to say.
Unfortunately, the family lives out of town now, so weren't able to get in. But thank you for your time.
Thank you for your bill. That will conclude the public hearing on Senate Bill 262. Moving to Senate Bill 503 from Senator Henderson. Please come forward and present your bill when ready.
Thank you, Mr. Chairman and members of the committee. For the record, State Senator Mike Henderson from the 3rd Senatorial District. Senate Bill 503 establishes a Uniform Public Expression Protection Act to protect Missourians from meritless lawsuits that aim to silence their First Amendment rights, based on a model act from the Uniform Law Commission, a nonprofit that drafts nonpartisan state legislation. SLAP, as it's known, strategic lawsuits against public participation, are lawsuits used to punish speakers with costly litigation to suppress free speech. Even if a defendant wins, the financial burden discourages them and others from exercising their free speech. It covers all forms of speech related to matters of public concern, not just those tied to public hearings or governmental proceedings, but this also includes posts on social media. It grants a clear right to appeal an anti-SLAP motion immediately, avoiding lengthy litigation. It requires a plaintiff to prove up front that they have a valid case with a chance of winning. So to put it really simply, what we're trying to do is keep somebody from trying to silence your First Amendment rights by suing you and discouraging you because they could drain your pocketbook. And I'd be happy to take any questions.
Senator, this appears to be identical to the bills that we've heard in this committee, I think, for the past 2 years. Is that correct?
That is correct.
Okay. Any questions?
Well, I don't think we've made any changes. There'll probably be a witness statement. It was verbatim, word for word, but I think it's exactly
Yeah, it looks
correct.
like it's identical to Senate Bill 1293 from last year, and this has been around, I want to say, since 2021. So you've got my full support, and I'm going to open it up to any questions. Seeing none. First witness in support, please come forward on Senate Bill 503. You'll have 2 minutes for your testimony. Make sure you fill out a witness form you can leave on the desk and proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Susan Klein, representing Missouri Right to Life, here to go on record in support of Senate Bill 503, and we thank the sponsor for bringing this bill forward. He kind of took my words, that the simplicity, I like the explanation to be simple. Sometimes, obviously we do have freedom of speech, but sometimes people or organizations are intimidated by the threat of a lawsuit and are encouraged to not speak out. And so because of this harassment and intimidation, we need to have some added protection for our freedom of speech. I haven't double-checked to see if there are other states that have increased, but at the last time I looked, there were 33 states that already have this, and the District of Columbia. So we strongly support this bill to give us added protection for our freedom of speech.
Perfect. Thank you for your testimony. Any questions for Susan? Seeing none.
Thank you.
Moving to the next witness in support of Senate Bill 503.
Good morning, Mr. Chairman and members of the committee. I'm Chad Stebbins from the Missouri Press Association. We represent 203 newspapers in the state of Missouri, and we are in strong support of this bill, which would protect journalists and others against frivolous lawsuits that could interfere with their First Amendment rights. News organizations and journalists across the country are frequent targets of these meritless lawsuits that aim to silence reporting through expensive and protracted litigation. Missouri's current statutes only protect conduct or speech undertaken or made in connection with a public hearing or public meeting. The Institute for Free Speech gave Missouri a D- grade in its February 2022 anti-SLAPP statutes report card. Missouri is one state where its anti-SLAPP statute has been interpreted through case law due to a lack of instruction about judicial interpretation. According to the Reporters Committee for Freedom of the Press, the Missouri anti-SLAPP law as it currently exists is very narrow. The current statute does not specify what standard a court will use to decide an anti-SLAPP motion or what evidence it will consider in making this determination. We strongly support Senate Bill 503. We need this law in the state of Missouri. It could potentially benefit every one of us. Thank you.
Thank you for your testimony. With time to spare, any questions for the witness? Seeing none, we're going to move to the next witness in support of Senate Bill 503. Please come forward. And James, I know you will be very concise and be under 2 minutes.
No way, Mr. Chairman. It's my first time before you. I plan on taking my full 2 minutes. No, James Harris, representing Institute for Free Speech. You're right, Mr. Chairman. This is a bill, I think, the last 2 years before the Senator Gannon had it on this side. Representative Perkins had it on the House side. It's passed both chambers at least twice. Has been in some civil proceeding or judicial proceeding bills. Wildly bipartisan votes, and with that, I'm happy to answer any questions.
I don't even think you used 30 seconds of your time, so feel free to save it up for the next round. Any questions? Seeing none. Next witness in support, please come forward. Senate Bill 503.
Good morning, Mr. Chairman, members of the committee. My name is Heath Clarkston. I'm here on behalf of the Missouri Broadcasters Association and in full support, and don't want to go past what the Missouri Press Association said because we agree with their analysis.
How do you feel with that D+ rating?
I don't like it. I need to get that up a little bit. I was more of a C guy, so
yeah. So at least get us to a C. I think maybe a B. This legislation should bring us to an A. Any questions for Heath? Seeing none.
Thank you.
Next witness in support. Seeing none. Any in opposition of Senate Bill 503? Seeing none. Any for informational purposes? Seeing none. Closing remarks.
Thank you, Mr. Chairman.
That will conclude the public hearing for Senate Bill 503. Now moving to Senate Bill 562 from the chiseled Gregory. Jacked Gregory. Not the little Gregory. Proceed when you are ready, Senator.
Thank you, Mr. Chairman. I do agree. I'm being called the jacked Gregory. I'm not sure why, but I'll take it. Thank you, Mr. Chairman. Before you, members of the committee, David Gregory, Senate 15, St. Louis County, Before you is Senate Bill 562. What this bill does is it seeks to modify the way we reward maintenance, the way courts reward maintenance. It's very confusing, and it tends to be the wild, wild west. Every time I talk to anyone, especially in family law, they have a very difficult time telling you how maintenance is going to go. You have no idea, and it's very scary for both sides, both parties. And of course, these days with more and more dual incomes and purposes and different types of families, I think it's particularly a good time to make these modifications. So what this seeks to do is really create a sound structure, a more predictable mechanism by which we can reward, our judges will reward maintenance. And that's what it does. It sets it up first by establishing how long the marriage was, right? I mean, most folks agree if the marriage is very short, a maintenance award should be anywhere between nothing and or just a few years. But if the marriage is a really long time, right, and one spouse particularly relied on the other spouse for many, many years, they, of course, should continue to rely on that spouse. And so that's what this does. It structures it. It makes it sound. I've got an expert attorney here that's going to come up and help explain any of the details. And with that, I'll take any questions.
Senator, this is a very complicated area of law that is in need of some reform, so I thank you for tackling this issue. Any questions for Senator Gregory? Seeing none. Oh, Senator Brown.
So what would this change? What is the current system for how that's decided, and how is this changing it?
Well, you can see in the bill, the non-bolded parts are the current system, and it's pretty vague. It basically says right now, hey, the judge can consider certain factors. That's it, right? There's no real structure. There's no real clear understanding of what we instruct the judges to do. And so that's what makes this the Wild, Wild West. If we just give a judge a few things to consider and that's it, with no other additional guidance or roadmap, like I said, it becomes the Wild West. You have no idea what they're going to do. And so this sets up a structure of three types of lengths of marriages, right? We're going to call it a short term, a moderate term, and a long term. So we're going to make that clear and structured. And then, of course, we come in and say these are the only three types of maintenance you can reward up to a certain amount of years for these specific purposes. So it just makes it much more specific.
Okay, thank you.
First witness in support of Senate Bill 562, please come forward. Make sure you have your witness form and you can proceed when ready.
Members of the committee, my name is Gary Stamper. I've been practicing solely in this area of the law for a very long 43 years. I agree that it's been the wild, wild west. I think Senator Gregory's bill codifies what the judges have been asking for a long time. Presently, in order for a spouse to receive maintenance, they must prove that they're unable to support themselves by means of appropriate employment and have insufficient property awarded to them in the dissolution to meet their reasonable needs. The problem with the static nature of our maintenance statute is that over the decades since I've been practicing, once a maintenance award is entered, there's a long-standing case law history which favors open-ended maintenance awards and prohibits limiting the duration of that maintenance award absent substantial evidence that some change in circumstances is going to occur. What I believe Senate Bill 562 addresses well are four fundamental principles. First, entitlement to an award under this section would be determined by a rule of statewide application, under which a presumption of entitlement arises in marriages of specified duration and spousal income disparity. Secondly, the duration of an award of periodic support should be related to the length of the marriage. Thirdly, it is good public policy for every citizen to be self-sufficient and economically dependent. Finally, the predictability of litigation outcomes reduces recurrent and insubstantial lawsuits that are dependent upon the discretion of a judge. I've given the same advice for 43 years to the possible maintenance obligor, and it is pay more to buy a sunset provision, because if a judge awards maintenance, it's running wild, and you have to go back to court in order to reduce or terminate the maintenance award. I've included some case law in the exhibits for the committee, including cases in which I've argued in the Court of Appeals, seeing trial judges reverse for awarding limited duration maintenance for a misapplication of the law or abuse of discretion. And so this area of the law is in need of your attention, because I think judges are looking for legislative imprimatur to assist them in fashioning maintenance awards that are fair to both parties. Thank you.
2 minutes, perfect. And we didn't even practice that this go around. Any questions for the expert witness? Seeing none, I want to thank you for your time in that field. It is a strenuous area of the law.
Thank you.
Next witness in support of Senate Bill 562.
Good morning. Thank you for hearing my testimony. My name is Brent Karashuk, and I am both an attorney, but also I've been a payor of maintenance, and so I feel like I bring a unique perspective to it, and quite honestly feel as an attorney that having experienced the process, that I need to do my part to bring about some constructive reform. This is not about trying to flip-flop or flip the entire system upside down. It's much more about refining the base statute in order to take into account the realities of what actually occurs in the courtrooms around the state. In my opinion, we need just a sensible, balanced updating of the statute, and that has been undertaken by many different states throughout the country, frankly, just because they're recognizing that people's circumstances and the way marriages work in today's world is considerably different than 50 years ago when the statute was first enacted or thereabouts. This isn't just about a bill to try to protect one end of the continuum versus another end of the continuum. It actually benefits both ends of the continuum, where you have people that in lower economic circumstances are oftentimes not awarded maintenance because judges know that they cannot turn off, or it's very difficult to turn off the maintenance, and so they're reluctant to start something that they cannot stop. And so, ironically, a statute that was intended to try to provide a fair framework to help people move forward actually ends up limiting the ability of a judge or impacting their desire to award maintenance for people that otherwise would need it for transitional purposes. And that statute, the statute, by creating these different categories, is really designed to encourage equal protection across all different economic brackets. On the other end of the continuum, in some cases, maintenance has become effectively a lifelong sentence that can't be turned off. And then, practically speaking, this limits people's ability to retire without having to go back to court, and is very difficult to go back to court and expensive and very unpredictable. And so there should be some parameter on the outside end so that people can have a reasonable expectation of retiring. And as Mr. Stamper said, there should be a codification of what the judges do believe in their case law, as evidenced by the case law, that people should have a duty to achieve a degree of economic self-sufficiency. And that is really at the root of what I think this statute is supportive of. I think that's essentially it, is that I think sensible change is needed, and the statute is really our best effort to try to accomplish that.
Thank you for your testimony. Any questions? Seeing none. Next witness in support of Senate Bill 562. Any other witnesses in support of Senate Bill 562? Seeing none. Moving to witnesses in opposition. Senate Bill 562. Seeing none. Any for informational purposes? Seeing none. Senator?
That close.
All right. That concludes the Senate public hearing for 562. Now moving to Senator Roberts on Senate Bill 340. And as Senator Roberts is getting up there, I want to make the committee aware, we will be moving into executive session, even though we have a couple other bills to hear. Senator Black will be here later in the hour, but we've got, I think, 5 or 6 bills that we'll just move through once Senator Roberts concludes his bill on Senate Bill 340. Proceed when ready.
All right. Thank you, Mr. Chair and members of the committee, for allowing me to present Senate Bill 340. A current provision in Section 600.063 of the Missouri statute allows a presiding judge to place on cases a waiting list if the public defender system is deemed unable to provide effective legal representation due to excessive caseloads. While this measure is likely intended to manage resource constraints within the public defender system, it has a significant unintended consequence that it undermines the right to a fair and speedy trial. This includes a denial of timely representation, potential constitutional violations, inefficiencies in case backlogs, and an account of judicial accountability and transparency. By repealing the provision, Senate Bill 340 ensures that no defendant is left without legal counsel due to administrative caseload issues. The bill upholds the constitutional right to counsel, promotes judicial efficiency, and encourages Missouri to seek long-term solutions to public defender shortages rather than resorting to measures that delay justice. I'd be happy to answer any questions, but there are some experts who might be able to speak more to the technical details as well.
Any questions? Seeing none. First witness in support of Senate Bill 340, please come forward. You'll have 30 seconds. You'll get a full 2 minutes. 10 seconds? Okay. I second that motion. Proceed when ready, Senator.
Thank you very much, Mr. Chairman. I'll try to talk quickly. Members of the committee, we appreciate Senator Roberts bringing this bill forward. I'm Jeff Smith, representing the American Civil Liberties Union of Missouri. For years, Missouri's use of the public defender wait lists deprived thousands of people accused of crimes of the court-appointed counsel that is required by the Sixth Amendment of the Constitution. At the start of 2020, there were over 4,600 people in the state who were on these wait lists. Over 600 of them were in pretrial detention. Many of them were waiting months, sometimes even years, to have a court-appointed attorney. They were charged with crimes, and there was an indeterminate amount of time, so they weren't even told, hey, you'll get an attorney in 2 months or 3 months. They just didn't even know in most cases, due to an overburdened indigent defense system. As a result, there were significant and devastating consequences for many people, consequences that were documented by the ACLU in a lawsuit. Despite being denied an attorney, people were still expected to navigate the court system while they waited. After being placed on the wait list and not having an attorney during critical stages of the criminal legal process, people had to go to an arraignment where bond is often determined with input from the prosecution without any advocacy from defense counsel. As such, they were often forced to remain in jail simply because they were unable to effectively advocate for a reduction in their bond amount or release on their own recognizance. Several plaintiffs in the ACLU's lawsuit, when attempting to argue for lower bond, were told by a judge that they had to wait in detention until counsel was appointed. And there were severe impacts outside of the courtroom as well. Many who were waiting in pretrial detention without the opportunity to confer with counsel or build a defense lost their jobs, lost their apartments, and totally lost any financial stability that they had, and also didn't have regular contact with their kids or spouse. While that was happening, potentially helpful evidence could easily be destroyed, lost, or eroded as key witnesses disappear or their memories fade. The judge in that case found that indigent defendants must be provided with counsel within 2 weeks after being found to qualify for it, and agreed with the ACLU that this practice was unconstitutional. So that's why we are here today urging the legislature to codify that court opinion.
Thank you, Senator, for your testimony. I do want to note on the fiscal note, page 3 of 4, because I was curious how this is going to impact the budget. And it says the Missouri Office of Prosecution Services and the Office of State Public Defender each assume that the proposal will have no fiscal impact on these respective organizations. Do you agree with that statement?
Well, I do at the time, because right now we've actually funded the system for the last few years. And so, right now we don't have a wait list, and that's why it's an opportune moment to try to pass this bill, because it wouldn't have a fiscal note. It would have had a significant fiscal note if we had done it when there were 4,600 people who were on the wait list.
Any questions? Seeing none. Next witness in support of Senate Bill 340. Senate Bill 340. Any in support? Seeing none. Any in opposition of Senate Bill 340? Seeing none. Any for informational purposes? Make sure you have your witness form, and you can proceed when ready.
Good morning, Mary Fox, from Director of Missouri State Public Defender. I don't disagree with any of the information that you just received from the last witness. Currently, the public defender has no one on a wait list and has had no one on a wait list since 2022. I do not foresee a wait list being created in the future, and there are other remedies included in the statute that a court can use if there is a determination that there's insufficient public defense resources to handle the cases. So I would think that changing the statute to reflect what the case law is would be a good option.
Thank you for that clarification. It answered the only question that I had. So any questions? Seeing none. Thank you for your time today. Any other witnesses for informational purposes? Seeing none. Senator, closing remarks?
No, thank you.
That will conclude the public hearing on Senate Bill 340. I now move that we go into executive session. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those against signify or say no. And the ayes have it. I now move that we call up Senate Bill 18 from Senator May. Did you time that perfectly? Wow, that's you. That's your seat. Do I have a second for Senate Bill 18 being before the committee? We have a second. Senate Bill 18 is now before the committee. This is Senator May's bill. I don't know if you'd like to remind the committee on what this bill does.
It's just
Make sure you use your microphone. We've got thousands of people listening at home.
Oh, wow. Good morning. It's just the $5 fee for the libraries. So basically, mostly everybody except us got this fee increase. I think it went to $15, something like that. And it just helps us to repair and maintain the law library for the judges and the clerks downtown. And the judges have been asking for it for years, and we've been trying to get it done for them for years.
Any discussion? Vice Chair, any questions? I now move that we do pass Senate Bill 18. We had a second. So, Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Coleman. May.
Are you sure?
Roberts. Schnelting.
All right, by 5-0, the motion passes. I now move that we do pass Senate Bill 235, creating Bentley's Law. Do I have a second? Having a second, the Senate Bill 235 is now before the committee. This is Bentley's Law relating to child maintenance orders for certain persons convicted of the offense of driving while intoxicated. This was presented several weeks ago. It's the same bill that was before the committee at least the past 2 years for those who were here. Any discussion on Senate Bill 235? This is Senator Henderson's bill. Seeing no discussion, I now move that we do pass Senate Bill 235. Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Aye. Brown 26. Aye. Coleman. May. Roberts. Aye. Schnelting. May.
Aye. You know that.
5-0.
By a vote of 5-0, the motion carries. I now move that we bring up Senate Bill 288 by Senator Henderson on increasing the circuit judges in St. Francis County. Do I have a second? Having many seconds. This is now before the committee. Any discussion on Senate Bill 288? Seeing none, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Coleman, May,
Aye.
Roberts, Schnelting,
By a vote of 5-0, the motion carries. I now move that we bring up Senate Bill 447, modifying compensation for jurors by Senator Trent. Do I have a second? Having a second, it is now before the committee. Any discussion on Senate Bill 447, modifying provisions relating to compensation for jurors?
Is that the one that's increasing compensation?
You are correct. Seeing no discussion, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Coleman, May,
Aye.
Roberts, Schnelting,
By a vote of 5-0, the motion carries. There's a lot of bipartisan love today in this room. I enjoy it. I now move that we bring up Senate Bill 558 by Senator Berger, modifying the number of judges in the 32nd Judicial District. That is Senate Bill 558. Do I have a second? Having a second, motion is before the committee. Any discussion on Senate Bill 558? Seeing none, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Coleman, May,
Aye.
Roberts, Schnelting,
By a vote of 5-0, the motion carries. I now move that we bring up and do pass Senate Bill 506 of mine, amending the Supreme Court Rule 1505 relating to continuing legal education requirements for attorneys. Do I have a second? Having a second, the motion is now before the committee. Any discussion on Senate Bill 506, modifying the Supreme Court rules on 1505 governing continuing legal education requirements?
So are you changing the requirements, or you just?
Use your.
He's gonna make me go off over here.
Well, that's why I saved it for the last one. This was a requirement. It's one additional hour that was put in place. I believe it was 2019, requiring certain education, and many attorneys are against this. I don't know if you were in the committee. The treasurer came, the attorney general, the lieutenant governor have all signed on a letter as attorneys to get rid of this requirement for the one additional hour per year.
At least one of the 3 ethnic credit hours required under rule must be devoted exclusively to explicitly. I think that's a good thing. Why wouldn't y'all want explicit and implicit bias? So that if you grew up in an area where you ain't encounter no other people that were like you, implicit and explicit bias is not. It's just teaching you how to deal with other cultures and stuff. You don't think you should be, you know what I'm saying?
I think that all of that is covered through other requirements on continuing education. And I'll share the slides from the last continuing education I did, specifically limited to this. And it's, in layman's terms, it's a hot mess. And it's more indoctrination rather than education. I've got the slides in my office I'll bring by.
Have you done any continuing education? Where are you on this, Senator Robert?
Maybe we just get rid of all CLEs.
You said what?
Just get rid of it all. Kind of joking.
You know what? Senator Gregory and I were talking about, the vice chair and I were talking about getting rid of all taxes as well. So maybe
now that's how I'll vote for it.
I have it on the record. Senator May and I will vote for getting rid of all taxes in the state of Missouri.
As long as we figure out another way to get the money, but you know what I'm saying. But
So any further discussion on Senate Bill 506?
I'm gonna be a no.
Seeing none, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Coleman, May,
I'm gonna have to be a no on that one.
Roberts, Schnelting,
By a vote of 5-2, the motion carries. I now move that we exit executive session and go back into public hearings. Do I have a second? Second. Having a second, I now move that we will bring up I don't know if Senator Black is here yet.
Did I get all the votes?
You got them all.
Okay, good.
I now move that we go into public hearing on Senate Bill 495 of mine. I'm going to turn the gavel over to, what do you call yourself, or what do they call you? The jacked Gregory. Senate Bill 495. Thank you, Mr. Chair, members of the committee. For the record, Senator Nick Schroer, Senate District 2, on Senate Bill 495. This is quite an easy one, as this is part of the, well, let me just back up. I will have a substitute mirroring the language that we had in the crime bill when it relates to the reporting requirements for prosecuting attorneys, so we can have a unified database with statistics that we can revisit as the crime bill hopefully is going to pass and get signed. So this will mirror, I will have a substitute mirroring the exact provisions, and this gives us another vehicle to deal with any type of public safety or judicial issues. So with that, I'll take any questions.
Thank you. Questions for the Senator?
What bill is this again?
Senate Bill
Senator
495.
495, okay.
Any other questions for the bill sponsor? Seeing none. Any witnesses to testify in favor of Senate Bill 495? Please proceed when you are ready.
Good morning, Mr. Chairman and members of the Judiciary Committee. My name is Byron Keelan, President of the Freedom Principle Missouri, in support of Senate Bill 495. To many Missourians, prosecutors are regarded as the champion of the people. Missourians rightly expect those elected to such a powerful position to ensure justice is served. However, what happens when reality is starkly different? When it is revealed that prosecutors have never truly embodied this idea that securing convictions at any cost is the priority. Research and judicial findings expose a darker side when those with immense power can cause as much harm to individuals as the rule of law as any criminal defendant. We saw this firsthand through the incompetence and corruption of former St. Louis City Circuit Attorney Kim Gardner. Local prosecutors are responsible for 95% of criminal cases in the United States. A prosecutor's discretionary power to charge someone with a crime or not is perhaps the most significant of their many duties. This power is the essence of control over the entire system. The prosecutor can influence the entire outcome of the process through the charges filed against a defendant. There is a notable lack of transparency in this discretionary power. The decision to charge or plea bargain is entirely discretionary and essentially unreviewable. This power gives prosecutors a greater impact than any other official within the criminal justice system. The factors leading to these decisions are made behind closed doors with no requirement for prosecutors to disclose their reasoning. As we saw with former Circuit Attorney Kim Gardner, her office lacked any uniform standards guiding these decisions, which are often made on an ad hoc basis, such as when a prosecutor learns of a defendant's criminal history, or in Ms. Gardner's case, which police officer filed the charges. Crime victims and the public deserve to know if they are safe and if their prosecuting attorney is fulfilling their duties. Requiring prosecuting attorneys to report their prosecution statistics would bring much needed transparency to this role. Thank you.
Questions for the witness?
Absolutely.
Senator May.
So you're saying that prosecutors now, who else, what other office lacks that same discretion that you're talking about?
I would say judges. The fact is that every time when an election comes up, we're always asked, how do judges vote? Or how should we retain judges? And the fact that there is no accountability, there's no record of how a judge rules on any cases. So I'd say that you could add judges to that.
And so what position, are you a prosecutor?
I am not.
Okay, and so you're just a regular citizen?
Yes.
Testifying?
Yes.
In favor of this bill?
Yes.
Okay, very good.
Any other questions for the witness? Seeing none, thanks so much for being here. Next witness to testify in favor. Senate Bill 495. Please proceed when you're ready.
Good morning again, Mr. Jack, Chairman. For the record, James Harris, representing FGA Action to testify in support. We just think comprehensive reporting requirements will allow the public, the legislature to assess the performance of prosecutors, see if there's trouble areas, see if there's an outlier somewhere, just having that information. And it kind of dovetails with the use of force FBI database that Missouri opted into a couple of years ago, which, again, transparency is a good thing. With that, I'm happy to answer any questions.
Questions for the witness?
Thank you.
Seeing none, thanks so much for being here. Anyone else to testify in favor of Senate Bill 495? Seeing none, anyone here to testify in opposition to Senate Bill 495? Seeing none, anyone here to testify for informational purposes? Seeing none, that concludes our hearing on Senate Bill 495. We will now hear Senate Bills 355 and 391. Senators, you may proceed when you're ready.
Good morning, Acting Mr. Chair. Is that correct?
You can call me Jacked, Chair.
Jacked Chairman.
Jack's Chairman. I will have to have that explained
Never
to
mind.
me. I hope I don't get arrested after that statement on a microphone. And rest of the members of this committee. For the record, my name is Rusty Black, and we know I get in trouble for saying that once in a while, and I represent the 12th Senate District. Senate Bill 355 removes the sunset for Basic Civil Legal Services Fund, which provides funding to legal services organization in the state to provide civil legal services and representation to eligible low-income individuals. This is set to expire currently on December 31st, 2025. This legislation has been voted out on Senate Bill 10. I think it's important, as those of us working in the legislature, to have more than one path in case something happens. So Senator Shore and I are trying to get this accomplished, and we hope you will help support us.
Stated simply just changes that sunset consistent with what we passed on Senate Bill 10.
Very good. Any questions for the senators? Saying none, it's a good bill. Thank you so much. Anyone here to testify in favor of Senate Bills 355 and 391? Please proceed when you're ready.
Thank you, Mr. Chairman. Members of the committee, my name is Mark Rhodes. I appear on behalf of the 4 legal aid organizations and programs in Missouri. I'm not going to take too much of your time. I do want you to know that the latest statistics indicate that the 4 Missouri legal aid programs closed over 17,000 cases in 2024. Many Missourians who need civil litigation services are certainly helped, assisted by these programs. Please help us retain the funding level for this. Thank you.
Thank you. Questions for the witness? Saying none, thanks so much for being here. Anyone else to testify in favor of Senate Bills 355 and 391? Please proceed when you are ready.
Good morning. My name is Christina Jackson. I am a board member for the Mid-Missouri Legal Aid Services, and I support bill number 355 and 391. I was diagnosed with lupus in 2005, among other health issues. I've been struggling so much with a stroke, seizures, kidney failure, etc. I received a letter from the Social Security saying that I was no longer disabled. I didn't know what to do, but I reached out to Mid-Missouri Legal Services, and they helped me. I was able to win my case and keep my disability services. Please vote for the Bill 355 and 391. Thank you.
Thank you so much, Ms. Jackson, for being here. Good job. Questions for the witness? Seeing none, thanks so much. Anyone else testify in favor of Senate Bills 355 and 391?
Thank you, Mr. Chairman. Michael Gibbons, representing the Missouri Coalition Against Domestic and Sexual Violence. to go on record in favor of both bills. Our clientele, which are survivors of domestic violence and sexual violence, often need to utilize these services, and it's extraordinarily important to those people.
Thank you so much. Questions for the witness? Seeing none. Anyone else testify in favor of 355 and 391? Seeing none. Anyone to testify against Senate Bills 355 and 391? Seeing none. Anyone to testify for informational purposes? Seeing none. Senators, you're recognized to close.
Thank you.
This concludes our hearing on Senate Bills 355 and 391. We will now hear Senate Bill 538. You may proceed when you're ready, Senator.
Thank you, Mr. Chairman. For the record again, Senator Nick Schroer, Senate District 2 on Senate Bill 538. This, quite simply, is just injecting into the current statute on stealing that if the defendant is in the possession of a deadly weapon while they are stealing, then this could be charged as a Class B felony. So with that, I'll take any questions.
Questions for the Senator? Senator Brown.
What is that currently classified as?
I don't know if that is something that they can charge if you're simply in possession. I know we have some of the prosecutors here. I know if you use a deadly weapon, it can be charged, I think, depending upon if the person's injured or not, as a Class B. So this is just consistent with what, if you have it in your possession while you're stealing, just consistent with what should be charged. But if I'm mistaken, somebody will correct me behind us.
Okay, thank you.
Further questions for the Senator? Seeing none. First witness to testify in favor of Senate Bill 538. Seeing none. Anyone here to testify against Senate Bill 538? Seeing none. Anyone here to testify for informational purposes only? Seeing none. This concludes our hearing on Senate Bill 538. Do I need a second? Move to adjourn. Second. We are now adjourned.